This hearing of the Committee on the Judiciary, Subcommittee on Courts and Competition Policy will now come to order. Without objection, the Chair is authorized to declare a recess. Today's hearing is the latest in the series of hearings I call an Antitrust System for the 21st Century. I have initiated these hearings to consider some of the issues raised by the bipartisan Antitrust Modernization Commission created by the Judiciary Committee. The question before us today is this: did the Supreme Court's decision in the Trinko and Credit Suisse cases sound the death knell for antitrust enforcement in regulated industries? In the 100-plus years since the antitrust laws were enacted, they have coexisted with other types of regulations. The reason Congress wrote both is that different types of laws provide different types of protections for consumers. Antitrust has always been concerned with promoting competition. When businesses compete, consumers win. But regulators may have other concerns, such as safety or policy goals, other than fair competition. In some cases, the antitrust laws may be in tension with other regulations. In rare instances, following one law might result in the violation of an antitrust duty. In a few of these cases, Congress has expressly created exemptions from the antitrust laws. In others, courts have implied an immunity, as is the case with certain rights under labor and employment law. Traditionally, such implied immunities have been narrow in scope because the courts have assumed that, unless Congress has said so explicitly, it intends for all laws it passes to coexist. But in Trinko and Credit Suisse, the Supreme Court appears to have abandoned this traditional perspective. In a most unjudicial way, the court went beyond ruling on the facts at hand and took a skeptical approach to the antitrust laws and the competence of our federal judges and juries in applying them. As a member of Congress and as the chairman of the Subcommittee on Courts and Competition Policy, I find this to be offensive. Our federal courts and juries handle complex matters all the time, and if the judges of the Supreme Court believe our system is not up to the task, they should make suggestions for improving the system, not take swipes at it in their opinions. The past century has been one of growth and innovation, and time and again, the courts have proven well capable of adjusting and refining the antitrust laws to rein in excess and ensure that antitrust rules are fair, efficient, and predictable. As a result, our antitrust laws police business successes but do not hamper legitimate innovation. That is an approach I support, but it is one that the Supreme Court appears to have inexplicably cast aside in these cases. In a few short years, the effect of those decisions has been devastating. Instead of the default being that the antitrust laws apply, Trinko and Credit Suisse have been cited to dismiss antitrust cases in the securities and telecom industries before they can even be tried on their merits. Nor is there anything that limits these decisions to their respective industries. Under Trinko, will courts start looking skeptically at all antitrust claims? I'm also concerned by what appears to be a trend of the Supreme Court legislating from the bench. As a former judge, I take the role of the court very seriously, and I also respect its limits. The regulatory laws in both Trinko and Credit Suisse contain savings clauses that Congress had specifically written in order to ensure that antitrust law was not displaced by regulation. Yet, that's exactly what happened. As Justice Thomas wrote in a scathing dissent in Credit Suisse, the regulatory statutes explicitly save the very remedies the court holds to be impliedly precluded. It is not every day that I agree with Justice Thomas, but on this one I do. The role of the courts is to interpret the law, not to rewrite the law or usurp the role of Congress in setting economic policy for this nation. If these cases were correctly decided, what more does Congress have to do to keep the antitrust laws in effect? I will now recognize my colleague, Howard Coble, the distinguished ranking member of the subcommittee, for his opening remarks.
Thank you, Mr. Chairman. Thank you for calling this hearing on the Courts and Competition Policy Subcommittee. Today's hearing could have profound implications for the jurisdiction of this subcommittee. It deals with two Supreme Court cases, as you mentioned, that if the critics are correct, could severely limit the reach of antitrust laws in regulated industries. I'm of two minds on today's hearing, Mr. Chairman. On the one hand, I'm an avid supporter of our federal antitrust laws. They are critical to ensuring that customers receive the benefits of competition, namely lower prices and greater choices. So to the extent that these decisions can be read as blanket exemption from the antitrust laws, I'm skeptical of their reach. On the other hand, I'm wary of over-regulating businesses, or what is worse, giving businesses conflicting regulatory demands. So to the extent that these decisions can be read as merely clarifying the regulatory burden borne by businesses, I am supportive. The fact that these decisions can be read two different ways really complicates matters, it seems to me. For example, is Trinko merely a limit on the extent that antitrust law can compel a dominant firm to deal with its rivals? Or is it a blanket antitrust exemption for the telecommunications industry, despite an antitrust savings clause in the 1996 Telecommunications Act? These are very complicated and weighty issues, as we all know, in antitrust law, and I'm pleased that we have such a diverse panel of experts to assist us in understanding the reach of these decisions. These questions are hardly just academic. Currently, members of both the House and Senate are meeting to reconcile the Financial Services Regulatory Bill. Both versions of that legislation contain antitrust savings clauses. Depending on what we learn here today, we may need to revisit that language to ensure that courts will honor congressional intent with respect to the role that antitrust will play in the financial services industry going forward. With that, Mr. Chairman, I look forward to hearing from our witnesses on this important topic, and I yield back the balance of my time.
Thank you, Mr. Coble. I now recognize John Conyers, a distinguished member of the subcommittee and the chairman of the full Committee on Judiciary.
Thank you, Chairman Johnson and Howard Coble, and my other colleagues here. This is an important hearing in many respects and unusual. The part that makes it so unusual for me is we have Attorney John Thorne, who argued the Trinko case as a witness. We're very honored to have you here. Yeah, but you were assisting those that argued it in the Supreme Court, where you did a lot better, and we thank you for coming here today, because we look forward to your analysis and experience in this matter. As both the chairman and Howard Coble have suggested, this is a hugely important matter, and this committee in the judiciary is very important. One way to look at it is that we're caught between Thurgood Marshall's calling antitrust laws the Magna Carta of free enterprise, and the fact that the courts are implying that antitrust is more subordinated to other regulatory concerns, and Thorne goes even as far as to say that well, he goes further than anybody else. The result in Trinko did not depend on regulatory context. And so there's a pattern and direction that's been determined by the courts that I think we don't disagree on. And the question is antitrust just a good law? And look, we've got the Sherman and Clayton Acts, and then Rodino, the Hart-Scott-Rodino came in even later. So what the committee is asking is, what direction are we going in, and what direction ought we go in? Now, I'd like to describe my take on what the relationship of the three branches of government are, because sure, the court takes swipes at legislation, but we take swipes at the court all the time. We don't do so badly ourselves. Matter of fact, we can take out a court decision if we want to, and they can find unconstitutional otherwise some other problem of our legislation. And of course, that's the genius of the system, isn't it? That we have three branches co-equal, and there's always these tugs of war and differing interpretations that are going on. And so I'm anxious to hear for the witnesses. I'll put the rest of my statement in the record, and thank you for calling this hearing.
I thank you, Mr. Chairman, for your statement. And are there any other statements? I am now pleased to introduce the witnesses for today's hearing. Let the record show that there was no affirmative response to my last question. Our first witness is Howard Shalansky, Deputy Director of Antitrust for the Bureau of Economics at the Federal Trade Commission. Mr. Shalansky is also a former Supreme Court clerk for Justice Antonin Scalia. Our next witness is Mr. John Thorne, Senior Vice President for Verizon Communications. Mr. Thorne successfully argued the Trinko case before the Second Circuit in 2004. Next, we have Professor Mark Limley from Stanford University School of Law. Finally, we have Dr. Mark Cooper, Director of Research for the Consumer Federation of America. Thank you all for your willingness to participate in today's hearing. Without objection, your written statement will be placed into the record, and we would ask that you limit your oral remarks to 5 minutes. You will note that we have a lighting system on the table that starts with a green light. After 4 minutes, it turns yellow, then red at 5 minutes. After each witness has presented his or her testimony, subcommittee members will be permitted to ask questions subject to the 5-minute rule. Mr. Shalansky, will you begin your testimony?
Chairman Johnson, Ranking Member Coble, and members of the subcommittee, thank you for the opportunity to appear before you today. I am Howard Shalansky, Deputy Director for Antitrust in the FTC's Bureau of Economics. The written statement we have already submitted represents the views of the Commission. My oral testimony is my own and does not necessarily reflect the views of the Commission or any commissioner. I would like to make 2 points in this statement. First, the Supreme Court's decisions in Credit Suisse and Trinko make it more difficult for antitrust law to play the important role it has long played in regulated sectors of the American economy. Second, the cost-benefit reasoning that led the Supreme Court to reject the private suits at issue in Credit Suisse and Trinko does not apply to public enforcement actions. Even if one assumes that those cases strike the correct balance in private suits, they should not be interpreted to block public cases where the federal antitrust agencies find that antitrust enforcement would yield additional benefits for American consumers. Before the 2004 Trinko decision, public agencies and private plaintiffs had long enforced antitrust law in a variety of regulated settings. Those cases range from enforcement against collective refusals to deal in the securities industry to refusals to interconnect with rivals in the electricity and telecommunications markets. The most dramatic example, of course, was the government's 1973 suit against AT&T that culminated in the breakup of the Bell system and that brought competition and lower long-distance calling rates to American consumers. Such cases show that antitrust law has played an important complementary role to regulation. It can reach conduct that regulation did not anticipate, fill in gaps left by agency rules, and often protect competition and innovation in a more targeted, less burdensome way than rules do. This is a role that antitrust, particularly public enforcement of antitrust, should be able to continue to play in the future, but in which it may be impeded by Credit Suisse and Trinko. Antitrust enforcement was not, of course, unlimited in regulated industries. The Supreme Court has long held that antitrust enforcement could not occur when it directly conflicts with regulation. But Credit Suisse and Trinko marked a significant change from that earlier doctrine. Credit Suisse extended the definition of conflict by blocking some antitrust claims that involve conduct not regulated by the securities law, and that could only conflict with regulation through judicial error. The result could be gaps in enforcement where neither antitrust nor regulation can reach harmful conduct. Trinko can be read to make it harder to bring antitrust claims against firms whose competitive conduct is subject to regulatory oversight, even when Congress has included a savings clause that expressly preserves the simultaneous operation of antitrust and regulation. In some instances, this might make sense. For example, in the specific context where an agency actively administers a rule whose standard for the competitive conduct at issue is more demanding on the defendant than antitrust law. In such cases, the courts are right to ask whether the marginal gains from antitrust enforcement outweigh the potential costs. Our concern is that Trinko could be read more broadly by the lower courts and block antitrust claims even when regulation does not directly or effectively address unfair methods of competition. Had the Supreme Court made clear that to preclude antitrust claims, a regulatory structure must, like the one at issue in Trinko, be directly relevant to the conduct at issue, be more demanding than antitrust law, and be actively administered, one might worry less about harmful side effects of that ruling. The risk for public enforcement agencies is that, given the Trinko court's emphasis on the potential costs of antitrust, lower courts will block public antitrust cases where the regulatory scheme falls well short of the FCC's implementation of the 1996 Act's competitive access provisions. Why did the court rule as it did in Credit Suisse and Trinko? Phrased broadly, the court's concern was that antitrust is always costly and in the presence of regulation is likely to have little additional benefit for competition. Yet that cost-benefit calculation for the kinds of private suits at issue in Credit Suisse and Trinko may differ greatly for public enforcement actions. A public agency's incentives are very different from those of private plaintiffs. The FTC does not collect revenue or otherwise materially benefit from successful competition enforcement. The government has no incentive to use antitrust law or the Federal Trade Commission Act against a regulated firm unless doing so can yield benefits beyond those the market already gets through regulation. The federal antitrust agencies therefore have more incentive and obligation than private plaintiffs do to assess the potential costs of an antitrust case, to evaluate whether antitrust enforcement can provide benefits not provided by regulation, and to balance the two in the public interest. As a result, public enforcement is more likely than private litigation to avoid claims that will be prone to judicial errors, that will interfere with regulation, or that will fail to yield net benefits over regulation. We therefore think it would be good policy for Congress to clarify that neither Credit Suisse nor Trinko prevents public antitrust agencies from acting when they conclude that anti-competitive conduct would otherwise escape effective regulatory scrutiny. Thank you again for allowing me to appear today. I'd be happy to answer any questions you may have.
Thank you, Mr. Shalansky. Mr. Thorne.
Likewise, I want to thank.
And Mr. Thorne, could you make sure that that mic is on? Okay.
Mr. Chairman, Mr. Ranking Member, Chairman Conyers, members of the subcommittee, thank you for inviting me to testify today, and thanks for the introduction. I want to clarify one small point. I argued the Trinko case in the Second Circuit, and unfortunately, I lost it there. My good friend Richard Toronto argued it in the Supreme Court, and the court was so impressed with his argument that there was no dissent from the decision in that case. So I'm very familiar. One effect of losing a case is you really do come to understand it well. I'm familiar with the Trinko case. I'm unfortunately much less familiar with Credit Suisse. I'm not an expert in SEC regulation, and so I'm not going to be able to say very much about that today. I want to point out, as a matter of Verizon's interest in this hearing, it's primarily as a customer. We buy, and these are rough numbers, $30 billion every year of products from other firms. We buy enormous amounts of healthcare and medicine and telecom infrastructure and devices of various sorts to build our networks. So we are extremely focused on effective, vigorous antitrust enforcement. And so, for example, I pointed out in my written testimony, we've brought affirmative, offensive antitrust cases to enforce the antitrust laws. We believe in it that strongly. Let me just make two quick points, and these are elaborated on in the written testimony. First of all, as I read the Trinko decision, it did not depend on a regulatory context. The facts came out of regulation because the thing that Verizon was selling to its competitors were things that had been compelled by the FCC's rules under the 1996 Act. So the fact setting was a regulatory fact setting, but the decision was straight antitrust. The Supreme Court's decision itself said so. It said that because of the thick regulation, that might have been a good candidate for regulatory immunity, but because of the savings clause, they weren't gonna think immunity. They were just going to apply the existing antitrust precedents. That's what the court said. Now, you don't have to take the court at its word. You can ask people like the people on this panel, what do you think the court meant? You know, does its reasoning or decision go broader? A few years back, Congress commissioned the Antitrust Modernization Commission to do a full study of how are the antitrust laws working. And in particular, one of the things that the commission was charged with looking at was how's the intersection between antitrust and regulation going. And so there's a chapter in the Antitrust Modernization Commission's report on the intersection of antitrust and regulation, how antitrust applies in regulated industries. If you spend time with this, as I've done, it's got a series of findings and recommendations for congressional action peppered throughout it. They're in sort of gray boxes. And most of the gray boxes have an asterisk or two indicating that one or another of the members of the commission disagreed with the particular consensus that the commission came up with. So they'll say, you know, Co-Chairman Urowski dissented from a particular recommendation, or Commission Member Kempf dissented, lots of dissents from the recommendations. There's one of the findings that the commission made that was unanimous. This was a bipartisan commission and unanimous finding that the Trinko decision, I'm going to quote from it, is best understood only as a limit on refusal to deal claims under Section 2 of the Sherman Act. It does not displace the role of the antitrust laws in regulated industries. So since Congress asked the commission to study how things were going and they looked at Trinko, their view, like mine, is Trinko did not displace antitrust in regulated industries. Now, the second thing I'll just say a word about, and it's elaborated on the written testimony, is there's a series of Supreme Court decisions going back to 1920 that say, this could have been a controversial decision back in 1920, but it's well established in the subsequent 90 years. If you get to a monopoly position lawfully by being the first in a market, by having a better product, by having a government franchise, if you get to a lawful monopoly, you are not required to dismantle the monopoly by giving it up to rivals. All of the cases involving refusal to deal, all of the Supreme Court cases involve a situation where you're voluntarily dealing with some folks and then you discriminate against your rival. In that situation, you can have antitrust liability for refusal to deal, but it's based on discrimination between voluntary dealing and refusal to deal with rivals or customers of rivals. And there is no Supreme Court decision that is different from what Trinko had said in 90 years of history on those sorts of cases. So thank you again for the invitation, and I look forward to the questions.
Thank you, Mr. Thorne. Professor Limley.
Thank you, Mr. Chairman, Ranking Member Coble, members of the subcommittee. I appreciate the invitation to speak here, and I want to start by saying that I agree, Mr. Chairman, with what you said in your opening statement. I think it is right to say that the antitrust law traditionally opposed implied repeal of antitrust law by regulation, that policy is a good one. Because it protects important competition interests in circumstances where regulated industries, where regulators might not protect those interests. And I also agree with you that wise policy is under attack as a result of the Trinko and particularly the Credit Suisse decisions, because the Supreme Court in the last 10 years seems to have backed off from the long-standing rule that there is no implied repeal of the antitrust laws in government regulation. What I want to spend my time today talking about just briefly is one of the unfortunate consequences, which is the problem that I call regulatory gaming. There are a number of circumstances in which private parties engage in behavior that harnesses pro-competitive or neutral regulations and uses them for exclusionary purposes. In the paper that's attached to my testimony, Stacey Dogan and I identify a number of those circumstances. Let me just give two examples. One is the Unical case, in which an oil company participated before a government-run standard-setting organization to set air quality standards in California, persuaded the government to adopt as a mandatory rule a particular set of air quality standards, and then revealed that it had a patent covering that particular technology, and no one else could use it unless they paid a super competitive price. Another example involves the pharmaceutical industry, which is engaged in a variety of techniques designed to try to extend the life of its patents covering certain drugs. One particular example involves so-called product hopping, in which pharmaceutical patent owners make minor changes to their products that don't affect their FDA regulatory approval, but make it impossible under the Hatch-Waxman Act for generic manufacturers to substitute generic drugs that are cheaper for those patented products. The difficulty here is that these are actions which, in the absence of a regulatory system, wouldn't exist. There wouldn't be a problem but for the fact that the government regulation helps the gaming to take effect. It gives it cover, it gives it monopoly power, it gives it mandatory authority. And in those circumstances where the regulation itself is not restricting competition, but private actions restricting competition, antitrust law can and should step in. The worry is that under Credit Suisse and Trinko, the reasoning of the Supreme Court suggests that antitrust law needs to back off. It needs to defer to the regulatory agency, not just in circumstances where the regulatory agency has made an affirmative decision to restrict competition, but even in circumstances where the regulatory agency has merely been silent, has not acted. And I think that's a mistake. Now, Mr. Chairman, you suggested correctly that we've long had a maxim in antitrust law that courts wouldn't assume the passage of a particular regulation impliedly repealed or limited the reach of that antitrust law. And I think that maxim is correct, and if the Supreme Court is no longer properly applying it, the right solution, it seems to me, is to reverse the presumption. Rather than simply having individual savings clauses in particular regulatory statutes, which seems in recent years to have been effective, we might consider a more general amendment to the antitrust law along the following lines. No regulation or act of Congress shall be interpreted to restrict or repeal the antitrust laws unless it expressly so provides. And a provision along those lines would serve the same purpose. It would enact the no implied repeal rule, but it would effectively reverse the presumption. Rather than asking in any particular case, did Congress intend this regulation to change the antitrust laws, the rule would be that unless Congress expressly said, here is an exemption from the antitrust laws, courts wouldn't be allowed to create one. And I think that would be wise policy.
Thank you, Professor Lemley, and also thank you for your submission of corrective language. Dr. Cooper.
Thank you, Mr. Chairman, members of the committee. Former Federal Trade Commission Chairman Robert Pitofsky edited a recent volume on antitrust practice in the last couple decades entitled How the Chicago School Overshot the Mark, the Effect of Conservative Economic Analysis on U.S. Antitrust. The Trinko and Credit Suisse rulings demonstrate that under the influence of conservative economics, the Supreme Court has not simply overshot the mark, it has gone off the deep end. These cases establish regulation as a barrier to antitrust oversight without requiring the courts to examine the effectiveness of regulation in controlling behaviors that are repugnant to both regulation and antitrust. This is particularly ironic since conservative economics generally takes a dim view of the ability of regulators to promote the public interest. If anything, conservative economic theory should have led the court to give antitrust a wider berth, not a narrower berth. Trinko, in particular, presumes antitrust has high costs and low benefits without demanding a careful accounting of the costs and benefits. It assumes false positives are plentiful, more likely, and more costly than false negatives without any empirical evidence to support that claim. It is the ultimate triumph of economic theory over fact in the antitrust space that favors corporations and regulation at the expense of competition and antitrust. After a decade in which we have watched large corporations inflict huge losses on the economy and society, WorldCom, Enron, Lehman Brothers, Goldman Sachs, and BP, the notion that large corporations acting on their private interests can be expected to behave in economically efficient and socially responsible ways, or that regulation can be presumed to be effective in protecting the public interest seems rather silly. We need every regulatory cop on the beat, and antitrust is one of the most important weapons policymakers have to protect the public from anti-competitive, anti-consumer business practices. To preemptively sideline antitrust in industries where it is needed most, those with the greatest market power, destroys the balance between regulation and antitrust that has worked well over the course of a century. Regulation is a second best, to be sure, but better than unfettered exercise of market power where market structure does not support vigorous competition. And I testified here on that issue in relationship to the antitrust modernization process. The antitrust laws are simultaneously applied to regulated industries to constantly probe for areas where competition can improve the public welfare. Regulators are not particularly adept at this role because it is not their core competence, and they have a tendency to be captured by the industries they regulate. The greatest value of the balance between regulation and antitrust exists where the market structure is least certain, where there is a transition between regulation and competition, or where there are a mix of competitive and monopoly elements in the market. Much of a 21st century economy resides in this middle range, and the telecommunications sector, which was the target of the Trinko case, is a perfect example. Congress was seeking to move telecommunications to a greater reliance on competition after a century of reliance on monopoly. The incumbent telephone companies were determined to prevent the loss of their market power. Under their litigious, obstinate foot-dragging, the effort to open the network collapsed. Both antitrust and regulation were aiming at the same goal, and the transition would have benefited from close antitrust scrutiny. The Trinko decision not only prevented the scrutiny in that case, but it severely restricted the likelihood of scrutiny in future cases. Trinko was a stretch of the antitrust laws that the court could have easily brushed aside if it was so inclined, without changing the terrain of antitrust laws. That was the easy and prudent thing to do, especially when citing the regulatory scheme of a statute that expressly stated Congress was not intending to restrict the applicability of the antitrust laws. Instead, the Supreme Court engaged in an extreme form of judicial activism using a weak case to make a major change in antitrust practice. The court could remedy the situation in future cases by making it clear that the Trinko decision applies only to private antitrust suits, and its application to private antitrust actions rests on the unique regulatory obligations and oversight embodied in the 1996 Telecommunications Act. Unfortunately, given the extremist ideology that underlies the decision, I am doubtful that the court will be inclined to fix the problem anytime soon. Congress should act swiftly to restore the balance between antitrust and regulation that worked so well in the 20th century. Thank you.
Thank you, Dr. Cooper. And now we will begin with questions. Mr. Thorne, is it not true that the issue in Trinko that went up to the Supreme Court was whether the conduct by the telecom company violated the antitrust law?
Mr. Chairman, that is exactly correct. The question in Trinko was whether Verizon, in providing access to its facilities, had done it in a way that was consistent with the antitrust laws.
And the court used dictum to suggest that, in general, the benefits of applying antitrust law in a privately brought case was few. In other words, there weren't very many benefits to be had for the bringing of a private action in a regulated industry context. Is that correct?
Mr. Chairman, with all respect, I read the case differently. I read it as having two parts, and give me a second, I'll explain it. First, the court asked...
And I think you did during your testimony.
But the dicta that you're referring to was not on the question of whether Verizon had violated the existing antitrust laws. The additional question, the second part of the decision, because the antitrust laws are somewhat plastic. It's a very brief statute. Don't restrain competition, don't monopolize. The court has the ability, if it wants to expand antitrust into places it's never gone before. And on the question of, the second question, not whether the existing antitrust laws were violated, the court found clearly they were not. But on the second question, should we take this occasion to expand antitrust into a new place? In that circumstance, the court thought for a whole list of reasons it would be a bad idea. And one of the things the court listed was the fact that regulators were already policing the very conduct.
Okay. Well, let me get Professor Limley's opinion about that.
Well, so I think Mr. Thorne's correct to say the court expressly considered should antitrust law not apply here at all, and they rejected that conclusion because of the savings clause. But I think it's also correct to say that the court went out of its way to express skepticism of the value and role of antitrust in an area that was subject already to regulation. And the court in particular said antitrust can do less good here because regulators are already policing the risk to competition, and it has a greater potential for harm. So I think the court was, in fact, going beyond its brief to decide the question that Mr. Thorne's case presented. Did this conduct violated the antitrust laws?
All right, thank you. Do you agree, Mr. Shalansky?
Mr. Chairman, I think that the court tried to draw two lines that will be very difficult to implement in practice. On one hand, as Professor Limley said, the court did not say that antitrust law, as clearly established, doesn't apply. It wasn't able to say that in light of the savings clause. It did, however, say that claims that would be an extension of the outer boundary of antitrust law could not be brought where there is a regulatory structure in place. There are two problems with that statement. Under the fact-intensive analysis of Section 2 of the Sherman Act, which tends to occur under the rule of reason and involve a balancing of pro versus anti-competitive effects, every case is going to be different on its facts, and identifying the outer boundary is not nearly as clear or straightforward an exercise as the court represents. And so lower courts could look at a case, say, well, we've never seen exactly this case before. It must be beyond the outer boundary and must be foreclosed in the presence of a regulatory structure. Which brings me to the second problem with the decision. The court does not establish a clear standard for the regulatory structure that must be in place before it precludes an antitrust claim. Does it have to be as elaborate, detailed, and competently and actively enforced as the Telecommunications Act of 1996? If so, as I suggested in my testimony, we may worry less about the displacement of antitrust. But what about a regulatory scheme that does not directly address the competitive harm at issue, but addresses some competitive harm, or is within the authority of an agency but not enforced? The court doesn't tell us whether or not that kind of regulatory structure is adequate, and our profound concern at the Federal Trade Commission is that lower courts could interpret such a weak regulatory structure to defeat antitrust claims, and not just outer boundary antitrust claims, good antitrust claims that could be brought under existing precedent.
Well, let me ask Dr. Cooper, do you feel that the ruling in Trinko taken together with, or ruling in Credit Suisse taken together with Trinko actually act to impose a presumption that actions brought by plaintiffs, both public and private, in a regulated setting are, in other words, the burden of proof has been shifted to the plaintiffs on these kinds of cases to establish that the antitrust laws do apply?
Actually, I think the example that the end point where Mr. Thorne wants to end up shows us the great danger. Of course, the argument he makes is that if I never dealt voluntarily, I never have to deal. And this is an industry in which it controlled access to its network for a century, never voluntarily making it available, and Congress said it's now time to make it available. For me, the critical question will be, if you allow that to happen especially in our technology industries, you will have a lockdown of all of the functionalities on which a broad swath of economic activity relies. That is the implication of this case, and he drew it. That implication is disastrous. It needs to be rebutted, I think, precisely by containing the damage that this case can do to the proposition which we can ask is whether the refusal to deal has severe negative economic and social effects.
Thank you, Dr. Cooper. I'll now turn to the ranking member, Mr. Howard Coble.
Thank you, Mr. Chairman. Gentlemen, thank you for your appearance today. Mr. Shalansky, you expressed concern that the FTC and DOJ could be precluded from bringing some antitrust cases in regulated industries as a result of these two cases. Do you have some suggestions for how Congress could legislatively repeal these cases for DOJ and FTC? A, and B, is this concern based on how Trinko and CSFB have been actually interpreted by district courts and courts of appeals, or are you concerned mainly as to how they may be interpreted?
Thank you, sir. Let me start with your second question first. I think our principal concern is, given the relatively few number of years that have occurred since Credit Suisse, and given the long cycle that our investigations and cases can occur over, that we are thinking about how these cases may affect our enforcement. We are always thinking in every action about these cases, about whether they impose an impediment. And we have current cases in which we are very attuned to the possibility that Credit Suisse and Trinko issues could arise. So at this point, given the relatively short time that has passed, our concern is mostly current and prospective than with particular decisions that have occurred. As to what could be done to protect the jurisdiction of the Federal Trade Commission, and I'm obviously not here to speak on behalf of the Justice Department, but I will speak broadly about public enforcement. Our concern is that public enforcers who have an ability to coordinate with regulatory authorities, to identify the gaps in regulation, to work interactively with regulatory authorities, to identify places where antitrust can be a useful complement, that we not be prevented by interpretations of Credit Suisse and Trinko from undertaking that independent policy judgment about whether antitrust would be more beneficial than costly in any particular setting where we're investigating a regulated firm. And so the particular kind of language is not something that I'd be prepared to provide you right off the top of my head, but a general thrust would be something that protects that jurisdiction, that expressly says nothing in the antitrust laws as heretofore developed would prevent the public antitrust agencies from exercising their independent judgment about the value of an antitrust case.
Thank you, Mr. Schlossky. Mr. Thorne, you stated in your testimony that Trinko would not have prevented the government from bringing its case at AT&T. One thing that's been suggested here is that the antitrust enforcement agencies, notably DOJ and FTC, be exempted from the Trinko and CSFB decisions. Would such an exemption undermine the regulatory clarity that you wanted to bring to bear with the Trinko case? Or in other words, would you favor a statutory exemption from TICO for DOJ and FTC?
Mr. Ranking Member, first of all, and I have to say this, my experience with both the Justice Department and FTC has been one of absolute admiration. The enforcers at the Justice Department and the Federal Trade Commission are first rate. They're the best antitrust enforcers on the planet. So I'm not going to say anything bad about their ability to enforce the antitrust laws, but the idea of breaking apart public enforcement and private enforcement under two different regimes it's a new idea. It's the first time in over 100 years under the Sherman Act that we've had a different enforcement regime for the two areas. So it started to raise questions in my mind, like if you're going to separate the private cases from the public cases, does that mean that the private cases can no longer tag along with the public cases? It just seems like there are a series of questions. Right now, the Justice Department is viewed as only a law enforcer. It doesn't set out separate policies or make laws. It just enforces the laws as they're written. Would this change that relationship that Justice and the Federal Trade Commission have? So I'm interested in the proposal. It's novel, and it seems to raise for me a series of questions that ought to be thought through.
And I didn't mean to imply, Mr. Thorne, that you were accusatory. I didn't mean to suggest that at all. Mr. Limley, let me start with you and then open it up to the others. Professor, how can Congress effectively communicate its intent to have antitrust laws and telecommunication laws operate side by side?
Well, I do think it's a problem because of the presence of savings clauses in the very statutes that have been interpreted, and that is why I think the best approach is actually to modify the antitrust law itself. To say that you should not assume or imply repeal from the antitrust law unless Congress expressly grants an immunity. I think that if done in the context of a hearing like this and with legislative history that made it clear that this was directed at cases like Credit Suisse, I think the message would be received by the courts that this was not, in fact, an area in which antitrust deference was appropriate merely because there was a regulatory system. And I've suggested in my written testimony some language that, quite brief language, that might achieve that end.
Mr. Chairman, my red light appears, but the others respond to my question.
Certainly.
Doctor, you want to start?
The goal that Professor Lemley outlines is precisely the place we need to get to, where the full force of the antitrust laws applies. And if the argument is going to be that somehow or another regulation has done the job, then that burden ought to be on the defendant in the case. That is, we need the antitrust laws to have full effect. The savings clauses tend to get thrown in at the last minute. They don't have a lot of legislative history. If there's any possibility that the Congress was carving out some sort of exemption, they're not well documented in the record, and I think that's a mistake. This is a moment, and this is a sector where we desperately need to make sure that we can get down that path to a more competitive environment. So switching the burden would be the critical point here. The presumption should be in favor of antitrust and rebuttable if there's specific regulatory language that one can cite and demonstrate effective regulation is actually in place, not just in theory.
Thank you, sir. Mr. Thorne, you and Ms. Schlesser want to weigh in?
No, thank you, Mr. Ranking Member. Thank you. I have nothing to add, sir.
I thank you, sir. I yield back. Thank you, Mr. Chairman.
Thank you, sir. Next, we will recognize Mr. Conyers for questions.
Thank you very much. Just for the record, Dr. Cooper, are you a lawyer?
I'm not a lawyer.
Okay. You seem to advise a lot of lawyers, though.
I've been an expert witness about 400 times, so you spend a lot of time with lawyers.
Okay. I've never recommended law school to a person your age, but there are honorary degrees probably floating around in the profession. Anybody want to comment on their thinking about the pattern of the history of antitrust law in America? Sherman Act, 1890, Clayton Act, 1914, Robinson-Patman Act, 1936, Hart-Scott-Rodino, 1976. Where we started off with, well, we were protecting people originally in the 19th century from consumer fraud, conspiracies, collusion. It was anti-monopolistic, price fixing. Then Clayton came in with the right of private lawsuits to enforce antitrust law in America. Hart, Scott-Rodino mergers, Robinson-Patman fair pricing considerations. Is this an era that's gone? We've sort of dealt with, we've had a rash of cases, big cases that we study in law school, but now it seems like the pendulum is swinging the other way, that we're trying to scale back and even, to me, sometimes strained interpretations of savings clauses, or that if you don't put a savings clause in, it maybe means that antitrust isn't being contemplated. What do you think, Cooper, Lemley, Thorne, Shalansky?
I'd offer two observations. It's interesting, you gave me the following key dates in the antitrust history: 1890, 1914, 1936, and 1976. I would point out that the Interstate Commerce Act is 1887. The Mann Act, which extended the Interstate Commerce Act to telecom, is 1910. And the Federal Communications Act, Federal Energy Regulatory, the Federal Power Act are all the early 30s. So The interesting thing is that the notion that we needed both regulation and antitrust is deeply embedded in that century of legislative history. So the idea that the court finds it repugnant to have dual jurisdiction just is inconsistent with that history. And I think it's really important, as I mentioned in my testimony, that Congress legislated both at almost exactly the same time, very consciously understanding it needed both. That's, to me, the most important lesson. The second point I would make is that the essential facilities doctrine, in an age where digital networks become the center of economic and communications and social activity, the access to that essential facility, that network, becomes more important than ever. And of course, that's the issue that the court was whacking away at in this case. So we're going in the wrong direction on both counts. We're claiming that we ought not have dual jurisdiction when that's clearly part of our history, and we're restricting the access to essential facilities when it's more important than ever to have access to those facilities.
I do think antitrust history has a pendulum problem. We started out with the antitrust laws to correct excesses of private behavior, and we succeeded, but in some sense we succeeded too well, and antitrust law started to reach too far into the regulation of private behavior. That pendulum has been swinging back for 30 years now, and I think it may well have swung too far in the opposite direction. It is absolutely desirable to have economic analysis and sophistication in thinking about antitrust. I guess I'd like to see us not push the pendulum back the other way, but see if we can get it not to swing so far in either direction and to center itself somewhere where we focus on economic analysis, we make the right decisions, but we're not simply saying we have to cut back antitrust or we have to expand antitrust at all costs.
Professor, what cases were you thinking of when you mentioned the pendulum had swung too far?
Well, if you look at the history until a couple of weeks ago when the Supreme Court decided the American Needle case, antitrust plaintiffs, both governmental and private, have been on a losing streak in the United States Supreme Court that had run 18 years and 18 cases without a single antitrust plaintiff's victory until American Needle. And I do think I think the concerns that were expressed in the early 1980s about not simply reacting to any private behavior by saying there must be an antitrust problem here were real, but I think the opposite concern is equally powerful. You cannot simply say, well, if there's any plausible justification that we can come up with for why private behavior might be acceptable, we should automatically defer to that behavior.
I quite agree with your analysis with the numbers, but name me a case.
So some of the ones, I think the Credit Suisse case that we're talking about here is problematic. I think some of the decisions that make it essentially impossible to prove certain types of antitrust cases, predatory pricing cases, for example, are problematic. Predatory pricing is often overclaimed, but that doesn't mean it doesn't happen. So the legal standards that we've created in cases like Brook Group may be too strict.
Mr. Doran.
Two quick observations, Mr. Chairman. First, listening to your summary of the dates, it's amazing to me how durable the very simple antitrust laws have been, and I think everybody on this panel agrees how important. Justice Marshall was not going too far in talking about the Sherman Act as a Magna Carta for free enterprise, almost on a par of the First Amendment guaranteeing speech and political participation. It's very important, and there's no. It's wonderful to see how durable it has been. But a small second note on Brook Group and on cases like it. These are the new cases that probably add up to the 18 that Professor Lemley talks about. If you think that it's important to have antitrust that's fair, efficient, and predictable, you need some clarity for businesses that are going to go out, like Verizon or other private enterprises, go out and then actually behave in the marketplace. So if Verizon is going to price a product, it needs to know at what point can we go in cutting prices to benefit consumers. At what point can we go before we'll be in some liability? We'll be hailed before a one-time lay jury and told we priced too low, we hurt our rivals, and now you pay treble damages to a class action. The predictability comes from having a test like don't price below your costs. That's something businesses understand. There's sometimes a debate about whether it's this measure of cost or another measure of cost, but the concept, don't price below your costs and you'll be okay.
But there's no law against that.
Well, that's what Brook Group held. But if Brook Group would be repealed, then businesses would not have the predictability of knowing. For example, if I lower my prices today and hurt some small rivals, I benefited consumers right away, but the rivals may not be able to keep up with price cuts. So there's a theme in the recent cases of saying a successful firm is allowed to do things that benefit consumers. A successful firm can cut price down to cost. A successful firm can innovate or invest, just like a smaller rival can do. These are things that are good for consumers, and these are decisions that I think on balance are good for consumers.
Your recommendation's good if the company has market power. In other words, if it's big and powerful. If it isn't, you can price wherever you want. And I'll be corrected on this. I've got a number of lawyers that are researching it now. Attorney Thorne, do you think you should have won your case?
The Trinko decision, I thought I should have won it in the Second Circuit, and I'm pleased that we won it without dissent in the Supreme Court, and I think it's good law and ought to stay good law. Thank you, Mr. Chairman.
Well, why didn't you win?
The Second Circuit has, in a series of cases, expressed skepticism not about the particular legal standard to apply, but the procedural posture of the case. So the way the case came up to the Second Circuit and then the Supreme Court was on a motion to dismiss. Trinko had not been allowed to take discovery, and we had not been allowed to take discovery of Trinko. So it was a full complaint with a lot of details, which gave you the information necessary to decide if there was a complaint there. But the Second Circuit is historically reluctant to decide things at a motion dismiss. They'd prefer to see a little discovery. And the phrase of Judge Sack, who was on the Second Circuit panel writing, he quoted, I think it was Dickens, it was some miscreant in Oliver Twist. Let's see what happens. Maybe something will turn up. Discovery was, and summary judgment was his preferred procedural route. I think that's why we lost in the Second Circuit.
I'm reminding of the sports metaphor, we was robbed. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Next, we will hear from Mr. Chaffetz for questions.
Thank you, and thank you all for being here. Mr. Shalansky, I'd like to start with you if I could. Recently, Congress passed a massive health care reform bill, and the FTC has historically pursued numerous antitrust actions in the healthcare field. Is there any concerns that what was passed in March will prevent the FTC from bringing price-fixing cases in the healthcare industry?
Thank you. That's an excellent question. We at the Commission do a lot of enforcement, as you noticed, in the healthcare sector. It's been historically one of the major regulated industries in which we have operated and continue to operate. And the healthcare bill, having been recently passed, is something that we are, of course, studying with a great eye to the extent to which there may be regulatory provisions that affect our ability to continue that enforcement.
I'm not an attorney, by the way, Mr. Chairman. I just want to know for the records. If you got one of those honorary degrees you're handing out, let me know, though. That would be great.
Well, I'm sure the law schools are already deciding among themselves which ones will confer you with an honor by next summer.
Thank you. Continue on, Mr. Slansky. If the FTC and the Department of Justice are given different substantive legal standard for bringing antitrust cases, how would you deal with all the private class action cases that would want to follow in their wake? Would trial bar lawyers, class actions, treble damages be allowed to piggyback on the government cases? How's that going to work?
Well, that's obviously going to be an extremely important area for policy, and to the extent that what the Supreme Court was primarily concerned about were what has been called the toxic combination of treble damages and class actions, how to preserve the good aspects of antitrust without the high error costs where, and not all such cases are inappropriate, I want to be very clear about that, but those that are have to be prevented from following on the heels. I would make two remarks about that, though. One is that when the public agencies win a case, that demonstrates that there is merit to the claim of anti-competitive conduct. And so to the extent that a firm may have further civil damages that flow from proven anti-competitive conduct, that's what the antitrust laws are there to prevent and to compensate the damaged plaintiffs for. But I would also add that where the federal agencies enforce, there may be ways for them to resolve claims without precedential effect. The Federal Trade Commission Act brings all of its competition law cases technically under Section 5. That is of not the Sherman Act, not the Clayton Act, but the Federal Trade Commission Act, which does not provide for automatic private rights of action, which does not provide for treble damages, and which also provides under the Supreme Court's Sperry decision and a number of other cases for a different standard potentially from the antitrust laws. It's not clear that private plaintiffs can follow on all of those actions.
Let me continue on here regarding Trinko here. You argued that, quote, the Second Circuit's erroneous construction of Section 2 would fundamentally transform the Sherman Act so as to require monopolists to pull their competitive punches, assist their competitors, convert themselves from retailers into wholesalers, and share monopoly profits on demand, unquote. Are you repudiating your earlier findings in the Supreme Court, and why, and what has changed?
Okay, I just want to be clear. I'm not sure I wrote those words or that the commission wrote those words.
Okay, assuming that it's not a quote, but generally the spirit of what I said there, I'm happy to repeat it, but I believe I am pulling from a direct quote here that was in the brief, at least.
Okay. I thought you were quoting the testimony. I'm sorry.
My apologies. From the brief.
Well, listen, the public antitrust agencies are just as concerned with sound antitrust enforcement as the Supreme Court is. And the public agencies would, I think, what they were expressing in that brief, and I want to be clear that I was neither an author of a brief nor am I authorized to speak on behalf of those that were, but my personal interpretation of what was written in that brief was a concern that refusals to deal not be too automatically punished. Because, as Mr. Thorne has argued, when you've successfully developed a product and successfully innovated in an area, it would be harmful, as the FTC has often stated, for American consumers if you automatically had to turn over that innovation, that invention, that product to a rival. That could harm competition rather than help competition. And I think what was being expressed in the brief was the concern that we not have a rule that, as we were talking about pendulums, that goes too far in telling successful innovators and successful competitors, you have to confer your advantage on your rivals. As Justice Scalia said in the Trinko case, that could harm competition, not help it. And I don't think we disagree with that. The question is, as my colleague, Professor Lemley said, where that pendulum is set. The court may have gone too far in Trinko.
Thank you, Mr. Chairman.
Thank you. Next, we'll hear from Mr. Polis with questions.
I joined my colleague from Utah as a non-attorney on the committee. Basic question, maybe one of you can help me with, is the concept, legal term, regulated industry, binary and clear, or is it a continuum of what a regulated industry is or isn't?
I think the answer is it's a continuum, and that's a significant part of the problem. In some sense, all industries are regulated. They're all subject to health and welfare regulation, environmental oversight, and that sort of thing. And so one of the worries is that if we defer if antitrust law defers to any area in which there is regulation, in the modern economy, that may be almost on everyone. Now, obviously, some industries are more heavily regulated.
If we take an example, we can comment on the publishing industry as an example. This would be an industry that has some regulation, especially regarding sale of books and pricing and so forth, that could be viewed within the antitrust realm. Is that one that falls somewhere on the continuum between, if anybody has familiarity with that industry, between regulated and unregulated?
I mean, I think it's probably a less regulated industry than most, but it's certainly the case that we wouldn't want antitrust to step away from actions in the book publishing industry. There were, in the last 10 years, significant antitrust cases brought against price fixing behavior among publishers, and we don't want to give cover to antitrust violations as private defendants have sometimes suggested in other industries, merely because there's a regulatory component.
And some of the regulated industries on that end are in fact regulated for other reasons, and indeed for primary reasons unrelated to competition policies. Is that correct as well?
Absolutely. Absolutely.
Do you have any examples of that you can give, what you might consider a regulated industry where the primary thrust of the regulatory structure is not necessarily around the same types of concerns that antitrust law address?
Well, I mean, so I think one example is securities regulation, right, where our interests are they're in some sense bound up with the working of the marketplace, but they're not with competition in the same sense antitrust law thinks about it. But environmental regulation obviously fits into that category as well. If we're restricting the way in which you run a coal mine, we're not doing it in order to encourage competition. We're doing it because we're worried about the environmental consequences.
And in your opinion, there's not any legislative legal language in the regulatory structure that's created for many of these regulated industries that specifically was designed by Congress to exempt them from antitrust?
I think that's right, and I think that's right precisely because the assumption until 6 or 7 years ago was that we didn't need legislative language to solve this problem because courts wouldn't impliedly repeal the antitrust laws merely because there was regulation. And it's that assumption that's been called into question.
So, right. So a legislative answer could take two forms. One would be modifying the Antitrust Act to explicitly not exempt regulated industries. The others would be to amend the relevant regulations for the respective industries to make it clear that nothing contained in those acts exempts them from antitrust.
Right, and I will just mention in the latter category that there are an awful lot of regulations out there. So the former seems the simpler approach.
I should ask, clearly the former is a simpler approach, also perhaps a difficult one in the aggregate. So would it in fact be legally constructive going forward when we look at industry regulation to include boilerplate language not exempting them from antitrust, or could that be taken as a point of evidence that in fact the ones that don't contain that language, it wasn't contemplated? Would you recommend that? Would you consider recommending that course of action to us going forward in the industries we regulate?
I think it is a worry, right? Because one of the canons of construction the courts use is, well, you said it here, you didn't say it here, so in the second category you must not have meant it to apply, which is why I think that the general approach within the antitrust laws is the proper one.
Yeah, thank you. It's just as a, and this would obviously, the counter-argument would be was a reaction to a precedent that didn't exist when the other laws were set up. You're correct, obviously, legislatively in terms of opening up all the various industries that are regulated, not the most likely political occurrence, but certainly going forward, absent an ability to modify the Antitrust Act itself, it certainly is a possibility that we could explore at the same time as we certainly explore in a clarification within the Antitrust Act. I appreciate your answers, and I yield back.
Thank you, Mr. Poulos. Next, Mr. Goodlate.
Well, thank you, Mr. Chairman. I appreciate your holding this hearing, and I appreciate this very interesting discussion by our panelists. To follow up on the comments of the gentleman from Colorado, you could also take it a step further and in writing revisions to our antitrust laws, say that when those laws are applied under circumstances specified in the law, they would supersede the the regulatory effect. My concern here is this. I'm very much a supporter of our antitrust laws, and I do not think we apply them as often as we should, and I share some of the concerns that have been expressed here. But quite frankly, I think antitrust has a more positive effect on our economy when it tells an entity, you can't do a certain thing because of its anti-competitive effect. But that still incentivizes that business to find a different way to deliver those services to their customers that they were told they couldn't deliver in that fashion because it had an unfair effect on their competition. Whereas with regulation, my fear is that the regulatory process is, you will do this, but you will do it this specific way. And that often has a very negative impact upon the incentive of businesses to be innovative in their process. So the clashing of those two ideas here is one that I respect, quite frankly, the court's concern. And Professor Lumley, let me ask you in that regard. You're talking about reversing the presumption. Help me juxtapose that with the Supreme Court's decision in Credit Suisse, in which they set forth this 4-factor test, which seems to me would put some burden on the defendant in those cases to first say, hey, there are regulations here, number one. Number two, the regulatory agency, whether it's FTC or somebody else, is indeed exercising their authority under those regulatory powers. Thirdly, that there would be a conflict that would exist between those regulations and the exercise of the antitrust decision. And then finally, whether the practices would be subject to conflicting requirements lie within the heart of the securities laws. Obviously, this decision could well be read to only apply to the securities industry, but that seems to be a pretty good test. What's your response to that?
Well, I think the first response is that test articulated in the abstract is not a bad test. As applied in the actual Credit Suisse case, it didn't work because the conduct that was in question, I think, was pretty clearly anti-competitive. And the regulatory decision to which the court chose to defer was not an affirmative decision to require the conduct or even to bless the conduct. It was merely regulatory inaction, the fact that the SEC hadn't brought an action against this particular conduct.
So good test, but bad decision.
Yeah, I think that's right. So I think so my worry then is what is it? How are lower courts who are reading this decision as applied in this context going to take terms like, is there a conflict between the two? Right? If there's a real conflict, if the regulation affirmatively says you have to do it this way, then yeah, you shouldn't hold people liable for violating the antitrust laws for doing what the regulators told them they had to do. That would be unfair. I agree with you, on the other hand, that if we have a choice between an antitrust regime that says don't engage in any competitive conduct but feel free to compete otherwise, we're better off choosing that over a regulatory system that tells people how they have to compete. And so my instinct would be to say we ought to limit the circumstances in which we think there's a real conflict between regulation and the antitrust laws as much as possible.
How does your, quote, reversing the presumption differ from this test? I mean, what would you add to that, or how would you differ from that in terms of attempting to reinstate some antitrust authority here without creating too many of these conflicts between antitrust enforcement and regulatory enforcement?
Well, I think the focus should, in fact, be on conflict. That is, I think if we simply had a rule that said the antitrust laws apply here, they haven't been repealed, they should nonetheless be, antitrust should defer to actual actions by the regulators, and they ought to defer in circumstances in which there really is a conflict so that the behavior by the defendant is compelled by the regulators, and so it can't be an antitrust violation as a result. You can't put a private company in the position of having to violate one law or the other. But short of that, if the government hasn't acted, and if the government's regulatory scheme doesn't put people in the position that they're going to run afoul of one regime or the other, unless there is an express immunity that Congress has adopted, I don't think the courts should be creating one by implication.
Mr. Chairman, my time's expired. I wonder if I might ask Mr. Thorne if I know he didn't profess to be an expert on the Credit Suisse decision, but he might visualize how this discussion that we've just had might impact his company and his point of view about this.
Well, my company is probably not affected by Credit Suisse because
You're not in the securities industry, but
the telecom statute has a very strong explicit savings clause, so antitrust is fully preserved for telecom. But I read the Credit Suisse decision. I noticed how deeply context specific it was. It didn't seem like a blanket rule was going to work. It was something that depended on the rules, depended on the facts. The Securities Exchange Commission there was an advocate for immunity. The Justice Department came in on the other side and said, no, we think we've got a way to make antitrust work despite your concerns about needing all the cooperation of the firms to aggregate capital. So it sounds like something where you'd want the advice of the SEC in crafting something that changed how the SEC-related rules were immunizing against antitrust conduct.
And if I might also ask Mr. Shalansky to talk about that very point. You had a conflict between two government agencies, not yours, but the SEC and the Justice Department. The Court of Appeals, the Department of Justice, and the SEC had decidedly different positions on the question whether security laws preempted the antitrust laws. Can you explain the position that the agencies took before the Supreme Court and the extent to which the court adopted the government position? Would the FTC take the same position today?
I can't speak to whether the SEC would take the same position today.
I said the FTC.
The FTC. I think that our position would be very much along the line. I mean, I can't speak for the agency, but our testimony today suggests that our testimony would be very much along the lines, or our position would be very much along the lines of the position the Department of Justice took. We as a public agency can make a reasoned judgment about whether the conduct we're attacking is reached or not by regulation, and whether or not we can frame the issue crisply enough that a court can separate the antitrust conduct from regulated conduct. There's a profound irony that the Credit Suisse court did not address. The very courts that they are saying are incapable of avoiding confusion between the securities laws and separate non-regulated antitrust conduct are the same courts they're saying will have to apply the four-part test whenever a conflict comes up. I find that to be a little bit strange. And just to address your other point, I agree fully that fixed rules that say you must do something in a particular way are less desirable than more targeted and more flexible antitrust enforcement. There is a risk after Credit Suisse and after Trinko that regulatory agencies will feel they have to be more rather than less aggressive because of fear that antitrust cannot play its backup rule. That was a concern of the Justice Department in the Credit Suisse case, and I think it's a concern that we at the Commission would have today.
Thank you, Mr. Chairman.
Thank you. I have one additional question. What is the cumulative effect on public and private enforcement of antitrust laws of the Supreme Court's decisions in Trinko and Credit Suisse? What is the cumulative effect? And I'd like to get a response from you all.
Well, I'll begin with addressing the public enforcement side of your question, and I'll try to say a word about private enforcement as well. Certainly at the FTC, we do a substantial amount of enforcement in regulated industries. Healthcare and electricity, just to name two, would be a couple of areas where we're active. We have to think very carefully in our enforcement decisions going forward about whether or not we will, in a given case, run into a Credit Suisse or a Trinko problem. So it certainly imposes a burden and a litigation risk on the agencies. As I said in response to Mr. Chaffetz, this is something that is going forward going to be a serious concern for us in healthcare, energy, other industries. On private enforcement, the only thing I can say is it must, I think both of these cases will over time and perhaps have already, although we can't observe cases that didn't happen because counsel said we can't bring the case. But I would imagine that it is the effect has been to reduce private enforcement.
Mr. Chairman, as a private enforcer, Trinko and Credit Suisse have not cooled our ardor at all in seeking to fully enforce the antitrust laws. As I mentioned in my written testimony, after Trinko, we brought a case in a highly regulated industry. We felt no deterrent from the Trinko decision. We think Trinko lines up squarely with the prior precedents and didn't change anything. And again, I'm not an expert, but as I read Credit Suisse, that's a case that is specific to the SEC context, and I don't see that precluding private enforcement. And if you look at the good work that the Justice Department, the FTC have done in this administration so far, I don't see these cases cooling their ardor at all either.
Thank you, Mr. Thorne. Very careful analysis. Professor.
I think the cases have emboldened the companies that are regulated to look for ways that they can game the system, because if they can engage in conduct that is within or finds shelter in regulation, they are more confident that they will escape antitrust scrutiny, and I think that's a bad thing.
That's my concern, and I've expressed it already, the dynamic of establishing the principle that if you never deal, you never have to deal. In industries where we have deeply interconnected networks and essential facilities, is leading us to a place where you get people with the ability to really frustrate the entry of competition.
Thank you. And are there any other questions from members of the committee? With that, I will conclude this hearing. I'd like to thank all of the witnesses for their testimony, and without objection, members will have 5 legislative days to submit any additional written questions, which we will forward to the witnesses and ask that you answer as promptly as you can to be made a part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any other additional materials. Today's hearing has raised troubling questions regarding the Supreme Court's attitude towards antitrust laws and the ability of the lower courts to enforce them. I remain concerned that this is part of a larger disregard held by this court towards the will of Congress. And with that, this hearing of the Subcommittee on Courts and Competition Policy is adjourned.